Let's go on the record on cause number DC 23-16285, McAllister versus AZZ Surface Technologies, Inc., or Surface Technologies et al. Counsel, make your appearances.
Your Honor, this is Jeff Whitfield on behalf of defendants.
And John Mazzell on behalf of plaintiffs.
You may proceed.
Your Honor, as the court will remember, you heard us on a motion to compel a few weeks back. I'll give a brief factual background here. The group of defendants, and the primary defendant that I represent is AZZ Surface Technologies, Rowlett. This is a facility in an industrial area in Rowlett. And what they do is they apply a powder coating that's superheated by more than 370 degrees to these industrial pieces of equipment inside of a facility, and it causes them to have a protective coating. The plaintiffs represent a group of people who purport to have worked across the street for some period of time, and they say that they got powder or dust on their cars and that the sun or something caused it to adhere to the car, and they're seeking damages for that. AZZ's position is what they describe as is simply not possible. And we have a motion to compel today, Your Honor. We had a couple of issues that were in that motion to compel. I'm pleased to report that at least one of those issues has been worked out between the parties. That was a question of documents showing ownership or title to the cars. We believe that at least 3 or 4 of the cars are no longer owned by the plaintiffs, and they've produced documents to us on that issue, and they do not have objections. So based on opposing counsel's representation, they've produced what they have. You know, we feel like that issue has been addressed. That simply leaves the second issue that was presented in the motion to compel. And that issue is whether we have the ability to inspect these cars. We initially requested to inspect the car in our first set of requests for production, the cars being tangible things, which Rule 196 allows us to request to inspect, and we asked to inspect those cars. We didn't want to enter their land, which you would typically then see a 196.7 motion for entry on land. We simply wanted them to make the cars available to inspect at a place of their choosing, even back at the place where they say the substance fell. The response to that request for production of the tangible things was, you need to submit a more detailed 196.7 request. While we disagreed with that, we tried to work it out. So we sent them a request for inspection saying, we want to look at the car. Our corporate representative wants to see the car, touch the car. Our expert wants to see the car, touch the car. And their response to that was, no, we don't think you have a right to that. In the background of this, we also took the deposition of their expert, who said that he had only spent 60 seconds trying to clean the substance off the outside of the car, and that he had got some of it off, but he'd only spent 60 seconds. So just further confirmed that we really need the ability to inspect these cars and see just whether these substances are on the car or how easy they are to come off with, you know, a simple, you know, layperson car washing. Now, the briefing that has been presented in this case has revealed a whole new issue, which I'd say, to Your Honor, this is tantamount to an early attempt to challenge the expert witness. And so that's really what I want to focus my presentation on today, is what I hope is a misunderstanding, a disagreement of interpretation of the discovery rules, and obviously something we need the court to umpire. And if the court will allow, I'd like to share screen and look at a couple of documents here as part of my presentation. May I be permitted to do that?
Yeah, give me 1 second. Sorry, I'm having some issues here. A second. There you go.
Thank you, Your Honor. I'm first going to just bring up clippings of the Texas Rules of Civil Procedure. I took these from the Texas Judicial Branch website, the current version of the Rules of Civil Procedure. And I'll point out, I think as background, let me expressly say what I understand plaintiff's position to be. I believe that plaintiff's position is that there was a deadline on which defendants were to designate their experts, and that at that designation, they also had to provide a report. And if a report was not provided by that designation date, then they have no duty to allow the expert to inspect the car. They have no duty to allow the corporate representative to inspect the car. They have no duty to allow me to inspect the car. And so really their focus is, I think, a question of what was our obligation on February the 7th of 2025 pursuant to the expert designation or expert disclosure. So I want to look at here, the Rules of Civil Procedure 195.5 says, and this is the change, as the court's aware, without awaiting a discovery request, a party must provide this listed information about the experts. And included in 195.5, it says documents, tangible things, reports, models, etc., prepared by or for. Now, as we know from the rule and the comment of the rule, 195.5 does not require a report be provided, but it says that if a report is provided, that report is to be provided without awaiting a discovery request. In other words, under 195.5, if a report has been prepared, you need to provide that immediately without a discovery request. That's our obligation. So that concept of if one exists, produce it, is then in the light in which we read the agreed schedule that the parties had reached. So I'm going to try to stop sharing this, Your Honor, and I'm going to bring up the agreed schedule sections and share this. And Your Honor will hopefully see what I've done here is taken clips from the agreed schedule that the parties have. And I'm going to first focus on the column on the right-hand side, Your Honor, because this is the designation of testifying expert witnesses for parties responding to affirmative relief. And as you'll see, it says that by this date, and I can pull up the actual scheduling order, but by February the 7th was the date for responding. So here, what we agreed to do was that rather than operate under that, just produce immediately, we agreed that by February the 7th, responding parties like us, defendants responding to affirmative relief, would designate, and as 195.5 says, if we have a report, we would produce it by this date. We did not read this highlighted portion on the right to say that even though 195.5 says produce a report if you have one, that somehow this was changing it to an obligation to produce a report. That's further confirmed, our understanding is further confirmed by our agreed schedule emphasizes that really the only party in this case that had a duty to produce a report were the plaintiffs, the parties seeking affirmative relief. Because as the court will see in the section of our agreed schedule that talks about this, the language is the same for each party. Those seeking affirmative relief need to provide the information for their experts just like we do. But for those seeking affirmative relief, if an expert was not designated or a report not submitted, that could result in the expert not being permitted to testify unless good cause is shown. That language highlighted on the left column is not present in the right column. And so, I'll pull up just, well, that won't be necessary. Your Honor, so again, our understanding with regard to the defendant's position was plaintiffs are seeking affirmative relief. They have an obligation here, a burden. If they're going to provide their report, that's great. They can depose our experts. In our designation, it says our experts are going to rely on the reports that have been provided, rely on inspection of the vehicle, rely on information and documents exchanged, and their opinions are going to be that plaintiffs are wrong, that this is not, it wasn't our material, that this is, doesn't adhere in this way. So I think one question we'd seek the court's guidance on today is, have we blown some deadline that we don't believe exists? And now our experts are not going to be permitted to testify because we didn't produce a report, even though Rule 195.5 doesn't say we needed to. And we say the scheduling order doesn't say we need to. I'm also, Your Honor, guided by your procedure. I'm going to show that clip here. I was reviewing your procedural rules, the 68th District Court. That's being shown now. And Your Honor, I'm mindful that in your court, if an expert is going to be struck, you take that very seriously. You will usually continue a trial setting if an expert is struck. So I clipped that from your 68th District Court procedures. And so for those reasons, Your Honor, I guess what we're asking is, the core of our motion to compel is our corporate representative, our expert, should be permitted to inspect these cars. Fact discovery is ongoing until April the 4th. We're deposing one of their experts later, March 26th, I believe it is. We're still in the middle of discovery, and they have no reason to disallow us inspecting the vehicles other than this position they've taken. So we'd also want...
Let me hear the other side.
Yes, Your Honor.
Thank you, Judge Hoffman. John Mazzell, I'd like to just kind of begin, got to give more of a breath. This case began in September of 2023. And the progression of how this has happened, and let me give you a little bit of a gist, and Mr. Whitfield kind of illuminated some of the issues. My client, I represent 8 ladies who have cars, and the cars are covered in this material that has literally gone through the clear coat, through the paint, and into the metal, and for whatever, under whatever process. So before this lawsuit even began, I obtained experts, a valuation expert to determine the damages, and also basically a chemist, an engineer, chemist, forensic person to analyze the substance on the cars of my clients and compare it with what possibly could be coming from AZZ, the defendant in this case. So in September 2023, the lawsuit was filed. They answered in October. In March of 2024, almost a year ago, I produced our retained experts reports. And then in May, we were going to have a conference to enter into an agreed scheduling order. And indeed, Mr. Whitfield or Mr. Delaney, I can't remember who it was, but we agreed to the scheduling order that the court entered in August of 2024. On top of disclosing in March of 2024, over a year ago, we produced some reports from the TCEQ, I guess it's the Texas Commission on Environmental Quality. And that report also tied, some of the language in that tied the substance that were coming from the defendant's facility to what was falling out onto the property next door, which was where my client's vehicles were parked. Okay. So what we have there is that I produced it back, the TCEQ report in March. They were aware of it because they were being investigated by TCEQ. Then in August of last year, I designated under 195, even though we weren't required to designate until January of this year, I designated in August all the experts, are retained and unretained, which would include the TCEQ, our valuation expert, and the chemist. Now, what has happened is that on around February 7th, which was the defendant's deadline. Now, keep in mind, Judge Hoffman, the reason why my clients agreed to push this out for a trial date that's going to happen the next several months is because we wanted an opportunity to hopefully engage in all the discovery and hopefully finish it up and basically get to trial if we couldn't get it settled. And we couldn't get it settled. We tried to mediate the other day and we couldn't get it settled. because largely my clients are driving in crowds and cars that are just in terrible condition. So now to the thrust of a legal issue, I think, Judge, that you have to encounter. On February 7th, and we filed a response, and if I may share my my screen, Judge, with you. Is that applied to it here? Yeah. Oh, here it is. Sorry, Judge. This is the scheduling order that the parties agreed to. And Mr. Whitfield is correct. And under 195.5, you don't necessarily have to provide a written report. That's not what you have to do. But the parties can agree to do so. And indeed, under this particular scheduling order, Judge, the parties basically agreed that they will serve written reports here for retained experts. Now, here's the problem. The problem is that on February 7th, and I'm going to share this, not this, stop share, and share. Excuse me. I can get it here. I asked them on basically February 12th, because they were now asking to inspect the vehicles. I said, why do you want to designate? Your deadline to designate on February 7th has passed. What they supplied in response to their 194 disclosures is, we've named these two expert witnesses, but they didn't disclose what their opinions were. They didn't disclose because they had no opinion, they had no data in which to do so. What they wanted to do is starting February 7th, which was their deadline, was to start the process of their experts doing the examination of the vehicles so they could go ahead and render opinions and the basis therefore, which they were required to do on February 7th. Now, obviously, Judge, if they'd asked me 2 months before, we would have made the vehicles available. Now, what's happened is our expert deadline's about to close or has closed, and we're willing to go ahead and extend that because we have one of ours is extended. But my problem is this, Judge. My problem is that they had all this time. They had they knew who our experts were, and they knew what they were going to testify about. And then they waited till February 7th to obtain their experts. And then they wanted to do their inspection. So, Your Honor, the amount of money that is being at issue here between my 8 witnesses is about $120,000. Now, because they basically did not engage in their proper due diligence and making sure that they did their inspection before February 7th so that they could render their opinions by February 7th so that we could do the discovery or depositions of their experts after that. Now we're faced with the situation of pushing this deposition further. So our position, Judge Hoffman, is simply this. My clients don't want to get to trial. They don't want to continue driving around in cars that have looked this way since 2022. We scheduled and agreed that we were going to get all our discovery done and designate whatever experts they want by February 7th. We were going to continue discovery and hopefully get reached on the trial date if we could not get it resolved. And now the defendants are saying, oh no, we're just now starting the process of our experts on February 7th, and it's probably going to precipitate a delay in this case. And so, Judge, our position is look, they had a long time.
Yes, this, Mr.
From
Whitfield.
March.
Whoa, Mr. Whitfield, why did it take so long for you to request this inspection?
And Your Honor, thank you for asking that. I can tell you that our expert's opinion says that it states their opinion. In other words, our experts have reviewed all the documents provided by plaintiffs, and our experts designation provides opinions. So what Mr. Mazzell has suggested that our experts now need to form opinions is untrue.
Do they even need the inspection then if we've already formed an opinion?
We need the inspection because now we would like to actually see the vehicles with our own eyes, not only our expert, but also our corporate representative. And so, yes, and I guess the other point to this, Your Honor, is that expert discovery wasn't even scheduled to close until March 7th. And as we know, the rules provide for supplementing and amending. So I guess two critical points here, Your Honor, that are just simply untrue. One, this suggestion that defendants did not comply with their designation, that their expert disclosure obligation is untrue. If you look at our expert disclosures, I'm happy to pull up and show those to you, Your Honor. They state that experts have reviewed the reports, reviewed the photographs, reviewed the information about these vehicles, and their opinion is that these findings are incorrect. They are invalid. This is an improper finding by the other expert. Just like what we imagine is going to happen at trial is their expert is going to say what their opinions are, what it's based off. And our expert is going to say, they're not right for the following reasons. And it's going to be a situation.
I know how experts work. Okay.
Yeah, Your Honor. So I
guess that what I'm not getting, I guess the disconnect is you're making it sound like the inspection is not really necessary for them to testify. Then why do we need the inspection to occur at all?
Your Honor, I'm not saying that it's not necessary for them to testify. I'm saying that it's part of the process that the rules permit to them. So sure, if they don't have the inspection, can our experts still testify? Of course they can. But the rules permit them to inspect the vehicles. And more importantly, the rules permit my client to inspect the vehicles. I mean, this is literally the textbook.
The deadline was March 7th for discovery?
No, April the 7th, Your Honor, is the deadline.
April the 7th. All right, this is what we're going to do.
Judge, if you give me 2 minutes.
No, I'm ready to rule. So,
okay.
And I appreciate it. I understand where you're coming from. You don't want to move the trial setting. So what I'm going to do is kind of split the baby here. We're going to have, so make sure you write all this down, guys.
Yes, Your Honor.
I want Mr. Measle. Is it Measle or Maisel? I'm sorry. I don't want to mispronounce your name.
Thank you, Judge Hoffman. It's Mazzell.
Mazzell, sorry.
Like Mademoiselle.
Okay.
That's okay.
So, do you mind if I there's a judge calling me? Give me 1 second. Okay, I apologize. Let me just
take time, Your Honor.
Hey, Judge, what's up? Sure. Oh, I don't do any criminal law, so I don't know. I'm sorry. No, I don't do any of that. Yeah. Let me think who's still over there. Ernie White's been there forever. If you want me to, I'm in the middle of a hearing and I could call a couple of my buddies. Oh, that's okay. No, why don't I do this? Let me call a couple of my buddies who are criminal law judges, and then I'll try to conference you in so you can they can answer your question. I just don't do that at all. So I don't know. Yeah. Okay. Okay. What is it? What are you testifying tomorrow? Okay. I'll call him after my hearing, okay? All right, thanks. No problem. Bye. Okay, sorry about that, guys. I thought it was an emergency, but it wasn't. Okay, so this is what we're going to do. You're going to produce the cars for inspection by May 30th. So the cars need to be produced by May 30th. Uh, you're going to have to produce a report based on the inspections, and those need to be produced for inspection to both the corporate rep and to the uh, expert. If they don't inspect, so you need to come up with a centralized location where those inspections can occur, and then the inspections will occur. Reports about the inspections will need to be made by April 7th so that we're not delaying this trial setting. And if the expert's not available to do that, the expert's not available and they won't be able to do the inspection. All right. So give me an order on that. Indicate the order was heard on, this case was heard for hearing on March 17th, 2025 over Zoom, that all parties were present and they were on the record. Do you have any questions?
Your Honor, just two questions from me. First, actually, sorry, three. First, you said May 30th, but I believe you meant March 30th was the date by which
March 30th. Yes, March 30th.
just to confirm for the record. The second question is, do I take your ruling to mean that there was not an obligation to file a report by February the 7th? That's why we're now issuing an order to file a report. Is that correct?
I didn't write that order. I think it's incredibly unclear. I'm trying to make this fair to everyone to give you a chance to get an inspection, but I also don't
Understood.
delay. So I'm not,
Understood, Your Honor.
that's
My
not
third,
for me, and
sorry.
that's not what I'm ruling.
Understood, Your Honor. My third and final question is: we had filed a supplement just to make clear that we are going to be applying a layperson cleaning compound and a scrub, like a buffer to the car. Just want to make sure that the court is aware that while the inspection is going to have a process, and I believe that I understand your direction is our
So
expert.
I didn't realize that. So I want to make it clear that this is non-destructive
Your Honor,
testing.
if there's going to be
Non-destructive.
If there's any damage under the car because of the inspection, then your expert's going to be required to compensate for that.
Understood, Your Honor. Non-destructive, no damage to the cars. Got it, Judge.
All right, get me that order by tomorrow. You guys have a great rest of your day, okay?
Thank you, Judge Hoffman.
You too, Judge. Thank you.
Thank you, guys. All right, Miss Guidry, are you here for a hearing? Miss Guidry, are you there?
Yes.
Hello, Miss Guidry. Hi, are you here for the 3 o'clock hearing? Okay, I'll be right back, guys. Hello. Yeah. Good, good. What's going on? Okay, guys, are you there?
Yes, Your Honor.
Okay, are both sides here on Lopez versus Ramirez?
I believe they're coming in now.
Good afternoon, Your Honor.
All right, Tony, are you ready?
I'm ready, Judge.
Let's go on the record on DC 24-22361, Lopez versus Ramirez. Counsel, make your appearances.
Good afternoon, Your Honor. Attorney Raul Ramirez here for defendant Delia Ramirez.
Hello, Your Honor. Chastity Guidry, attorney for defendant Luis Verdugo.
Is that everyone?
I think we're missing the plaintiff.
There's a Miss Castaneda. Who's that?
Good afternoon, Your Honor. I am going to be the interpreter for Mr. Ramirez's client, Delia.
Okay. And where is the plaintiff's attorney? Who is Luis Verdugo? What is his role?
He's the defendant, Your Honor. There's
Okay.
two defendants. The plaintiff is Jose Guadalupe Mina.
And you're the interpreter for who exactly?
For Mr. Ramirez's client, Delia.
Okay, for one of the, is she here?
She's in my office, Your Honor, but she wants to be aware of all the proceedings. So Mrs. Castaneda will be, I guess, translating to her what's going on in the hearing, but she's here in my office just because she wants to know what everybody says.
On that note, Mr. Ramirez, would you mind telling your client to answer the phone so that I may interpret for her? I've been trying to get a hold of her and she won't pick up.
I will be happy to do so.
Thank you.
All right. Is Tony, are you there? I mean, sorry, Rhonda, are you there?
Yes, Judge, I'm here.
Can you call Mr. Ontiveros on this case and find out what's going on, why he's not here?
Sure. And also, can I get the spelling for Mr. Garmites's name? It's not on the docket sheet.
Ramirez?
You're on the pleadings.
My apologies, Your Honor. I'm here for Mr. Tilford, but my name is on the pleadings, just right below Mr. Tilford's name.
I don't have that. Can you just spell it for me real quickly, please?
Yes, let me go ahead and rename myself in the Zoom to make it easier.
Thank you.
Judge, I'm getting the voicemail. I'm trying to send an email to him now.
Castaneda.
Gracias por llamar a Ontiveros Law Firm. Thank you for calling Ontiveros Law Firm. Actualmente estamos en la otra línea. We are currently on another line. Por favor, déjanos un mensaje con su número.
Does anyone have a cell phone number for Mr. Ontiveros?
I do, Your Honor. Let me go ahead and call her. Judge, I just spoke with Ms. Ontiveros. She advised me that they had it set at 3:30 on their calendar, but the attorney who will be appearing is logging on as soon as possible to appear.
Okay. All right, Ms. Ontiveros, are you here for the hearing?
This is Attorney Megan Knuth with the Ontiveros law firm, Your Honor. I apologize. I had this calendared at 3:30. I do apologize.
Yeah, there's two different hearings. One's at 3 and one's at 3:30, so that happens. All right, let's go. So did you get her announcement?
It's
Okay.
on the screen. Oh,
All
is
right,
it?
so let's start with the special exceptions.
Your Honor, I'm going to defer my time for the special exceptions. This was on the first pleading, and the plaintiff has amended that pleading. And so I filed an amended answer and I pleaded the jurisdiction. And so I'm going to not go on the special exceptions.
Okay, you're going to just pursue the plea to the jurisdiction?
Yes.
Okay, let's proceed.
So I believe we're going to go with Mr. I'm sorry, counsel, can you state your name again for Mr. Tilford's firm?
Oh, Ms. Ramirez.
Mr. Ramirez, okay. Yes, I believe his was set, and I had agreed to his pleading, so I will let him go first because he filed the plea to the jurisdiction.
Okay, go ahead.
Thank you, Your Honor. Your Honor, good afternoon. May it please the court. Your Honor, on November 16th of 2024, the plaintiff in this case, Mr. Jose Guadalupe Mena, filed an original petition for divorce. In that petition, he made specific claims about division of community property, and even in his plea for temporary orders, asked the court to make a decision regarding exclusive use of the property that is in dispute before you today that is related to this proceeding. I believe the exact address of the property is 1733 Palo Alto Drive, Mesquite, Dallas County, Texas. At the same time, several months later, he filed an original pleading in this court asserting claims of breach of contract, fraud, and unjust enrichment. The reason we filed a plea to the jurisdiction that is set before you is because those all stem from the same set of facts that are during the marriage. Effectively, plaintiff in his petition for divorce has made claims about community property existing, but at the same time, he's asking this court to make claims regarding fraud, specifically having to do with the transfer of deeds. So back in April, I believe, of 2021, the plaintiff executed, conveyed, and recorded community property where both him and my client, Mrs. Ramirez, are named as.
So, I've actually communicated with Judge Brown about this, Judge Mary Brown, who's the family court judge. She has said that, at least at this point, she's happy to let me hear this. I do think that if Judge Brown changes her mind and says, hey, look, I have dominant jurisdiction here, Judge Hoffman, you need to stand down, I'm happy to stand down. But given the nature of this, because as I understand the facts, the allegation is that the wife took the deed, or that she claims that the ownership of the property was deeded to her, and then she deeded it to her son, correct?
That is correct, Your Honor. You are correct.
And both the wife and her son are both defendants in this case, right?
That is correct.
So, yeah, so that wouldn't necessarily be resolved in the family court, that issue of title, maybe possession, maybe, but title wouldn't necessarily be. So until Judge Brown says otherwise, I'm not going to debate this case or grant a plea to the jurisdiction. So,
Your Honor, would the court consider if I were to make an oral motion to consolidate this case into Judge Brown's case, since they are of the same operative set of facts?
if she wants to do that, she can, but I'm not going to do that. Leave it up to Judge Brown. If she wants to do that, just tell her I'm not opposed. It's totally up to her. But I'm not going to do that. That's up to her to do.
Okay.
She has the older filed case. All right. Can you get me an order on that?
Yes, Your Honor, I will get you an order.
So, yeah, give me an order that indicates this was heard on the record, on Zoom on March 17th with all parties present, and then get that to me by tomorrow and make it clear in the order that this was without prejudice to raising this issue in Judge Brown's court and DF, whatever number that is.
Your Honor, do I have the court's permission to put in the order that this court has no objection and defers to Judge Brown on whether or not she wants to exercise dominant jurisdiction in the future?
Sure, that's fine.
Thank you, Judge.
All right, anything else today, guys?
No, Your Honor.
Not from our end.
And you guys, I was just looking at, so we don't have a trial setting on this case. So let's go ahead and set this for trial. Do y'all want to look at kind of a late 2025 trial setting?
That's fine with me, Judge.
Your Honor, I do have a motion for sanctions, or I'm asking for a dismissal for my client, Mr. Luis Verdugo. So I will be setting that for a hearing after we conclude today.
Okay. When do you want to set this for trial?
When is the earliest available that y'all have, Judge?
Probably December.
Okay. Do you have like the first week of December?
Yeah. Let me double check. Yeah, December 6th, wait a minute, is this 20? Yeah, December 6th, 13th, December 6th or 13th. What do y'all prefer?
Your Honor, December 6th of this year, I believe, is a Saturday.
Am I looking at the wrong? Oh, okay.
I'm showing December 2nd, December 9th, and December 16th
All
for
right.
jury.
December 2nd or 9th is fine with me.
Or I guess December 2nd, 9th, or 16th.
December 2nd works for
Wait a minute, December. Oh, what is going on here? Okay. Sorry. December 2nd, 9th, or 16th. Yeah, all those work. Probably the 16th would be a little better. We have a ton of trial settings on the 2nd and 9th. So let's do the 16th. Does that work for everybody?
the 16th works, Your Honor.
Yes.
All right. And then who do we want to use as a mediator for this? Ken Rubenstein, King Pfeiffer, Jim Jordan.
Oh, let's use Mr. Jordan. That would work great.
Mr. Jordan, I agree.
Does that
Okay.
work?
That's
All
fine.
right. Go ahead and appoint Jim Jordan on this. Anything else we need to chat about today, guys?
No, Your Honor.
No, you're on.
All right. You guys have a great rest of your day. Okay.
Thank you,
Thank you.
Judge.
You.
Have a good day.
You too. Bye-bye.